Enjoy seeing you on weekends.
Oh, thank you.
So when, thank you all for coming on short notice. The legal team in the opioid litigation and I thought it was important to address this matter head on with as much transparency and detail as possible. I want to start with some background on what was filed yesterday. Purdue Pharma filed what's called a notice of removal to federal court in an attempt to transfer the state's opioid lawsuit to the federal multi-district litigation in Ohio with hundreds of other opioid-related cases. In filing this, Purdue breached its agreement signed on July 24, 2017, where it agreed that it would not try to remove the case to federal court. The company deceitfully claims that the state's lawsuit includes federal issues that Cleveland County District Court has no jurisdiction over. Judge Bachman has already reviewed the federal preemption issue in this case and disposed of it. The simple fact is that our case does not belong in federal court. Purdue is simply abusing the legal system in order to drag out the litigation for as long as possible. And this latest move shows just how stampeded Purdue is in having our case tried by a jury of Oklahomans. It seems convenient that Purdue filed their notice one day ahead of our deposition of their witness regarding a letter that they published in the New York Times claiming that they were partners in the fight against the opioid crisis. It's also convenient that this tactic is aimed at stopping the other depositions scheduled to take place in the next few weeks, including one that seeks to find out the political activities of Purdue in the state of Oklahoma. Purdue has instead taken the step to ensure that it can continue to fraudulently drive up the sales of its opioids. It is clear to us that our case is their biggest fear in the country, and they will do anything in their power to stop it or drag it out. And they should be afraid. We have been unwavering in our position from day one. We will not join the cases before the federal court in Ohio, and we will hold Purdue accountable for the thousands of deaths, for the generation of addicts, and for the billions of dollars that they have caused to our state. They want this case to go before a judge in Cleveland, Ohio, and a room full of nameless, faceless attorneys from all over the country. We want it to go before a judge in Cleveland County, Oklahoma. So, in response to yesterday's filing, we are preparing to file a motion to remand stating that the lawsuit should remain in Cleveland County. And because this epidemic is so relentless, so unforgiving in the death and devastation it causes, we have also asked for an emergency hearing on our motion to remand. We are confident in our position that this is nothing more than a stall tactic by a company terrified to answer to its Oklahoma victims. And we have great confidence that the federal judge will see that too. In the meantime, we will continue to prepare for our case. We have a trial set for next May, and we are confident in our ability to be successful in advancing the state's interests again before a jury of Oklahomans. Thank you all again for being here, and I will now be happy to take questions. With me today are our lead counsels in the case, Judge Mike Burridge and Reggie Whitten, and the general counsel here in the Office of Attorney General, Abby Dilsaver. Questions?
I'm trying to, when do you hope to have this emergency hearing with the federal judge, right?
Well, we're filing our motion here in a matter of minutes. Our hope is that the judge will set this in the next several days.
I've been unable to see the order. What was the judge's ruling on that? I've checked Pacer and I've not been able to find the judge's ruling.
Well, what happens when there's a notice to remove is that notice will cause the state proceedings essentially to be frozen until the judge rules. So we filed a responsive motion that I've described today. Other questions?
I guess as a technical matter, we're trying to decide, has a judge signed something at this point that says it is removed and now you have to undo it, or is it just a request to remove it?
So, Judge, you want to take that?
Thank you, General.
Sure.
The law provides that when the notice of removal is filed, that stays the state court proceeding, and there doesn't have to be an order of any kind entered.
Until the judge's ruling?
Well, the motion to remand, we're filing today, this afternoon, and then the judge will make a ruling on that as to whether it remains in federal court or be remanded to Judge Bachman in the state court.
So I think that we have copies of the stipulation that I referred to that was entered into between the state of Oklahoma and Purdue Pharma, and I think that's been distributed. But you will clearly see that facially Purdue has breached their contract with the state with regard to promising not to attempt to remove the case to federal court.
In general, if I might put a little background on how this occurred. After the defendants were served, they wanted certain concessions made by the state with regard to certain time periods. And so we said, okay, we'll do that. What are you going to do about removal? And they said, we will agree not to remove if you give those the concessions that we want. It's two sentences, and but it clearly states, and we passed out copies of it, that the first one says that the state's case is properly brought in Cleveland County, and the second one is that they will not remove it. Now that was back in July, and it was filed a public record on July the 27th. So the question comes up, what prompted this removal? Because we never amended the petition. It's the same petition we had filed, but we were going to take the deposition that related to the political contributions made by these companies. In other words, the deposition was to take place tomorrow, and they were going to have to produce a witness to swear under oath what political contributions they had made to candidates in Oklahoma. Then they filed the removal. So read into that what you may, but it's very obvious that they did not want to disclose to the public the political contributions that they had made in the state of Oklahoma.
Mr. Witten, you have anything?
No, sir.
Okay.
Unless you have a question.
So
Other questions?
So they're stipulating that they wouldn't try to have it removed. Is it your position that's a contract that they can't violate?
Yes, and there's quite clear that it's a contract, and it's quite clear that it's enforceable in federal court, and it's quite clear that it can be used to remand the case back to Judge Bachman. The federal court here in Oklahoma City not long ago entered a similar order in a case that we had that they agreed not to remove, and then they removed it, and it was remanded.
Was there agreement binding on the other pharmaceutical companies as well?
Yes, and you'll see it in the stipulation, Nolan, but all of them joined in the stipulation that the case was properly filed and that they wouldn't remove it. It was every one of them, not just Purdue. Yes.
Anything else, Randy?
So if they get their way,
Yeah.
it'll be moving to Ohio, or would the judge be coming down here?
No, it would be, if they get their way, it would be transferred to Columbus, Ohio.
Anybody else? Well, listen, we appreciate y'all coming out today. This
Yeah.
is important stuff, and we appreciate the coverage.
Yeah.
So if you have any follow-up questions, feel free to get with Alex, and we'll get you anything you need. Okay, thank you.
Thank you very much.
Appreciate it.
Sure. Yeah, nice to meet you.
Yeah, you too.
All right, take care. Thank you all.
Mind if I read over your shoulder again?